Today we're looking at creditors' rights in bankruptcy, and we're going to begin our discussion by talking about secured transactions, which are governed by Article 9 of the Uniform Commercial Code. And all this secured transaction revolves around the idea of a security interest, and that is an interest in personal property that secures payment. If the debtor defaults or fails to pay on a loan, the creditor can then go and recover or repossess the collateral, the property that has been pledged to stand good for the loan. Why do we allow a secured transaction? Well, the reason is that it encourages lenders to extend credit to people whom they otherwise might not extend credit to. As far as secured transactions, there can be a two-party secured transaction where the seller and lender are the same entity. So for instance, if you went to a car dealership and purchased a car and the dealership financed it for you, that would be a two-party secured transaction. Or you could have a three-party secured transaction. Suppose that you got a loan from a bank and then took those proceeds to purchase the vehicle from the dealership. There you have three parties involved, and that would be a three-party secured transaction. We're also going to talk a little bit about unsecured debts and the means that can be taken to collect on those through statutory liens and judicial or judgment liens, but our primary focus today is on those secured transactions. So the first step in establishing a secured debt is to create a security interest. And the first thing the creditor has to do is attach to some sort of collateral. The attachment gives the creditor an enforceable security interest against the debtor. Now there are three requirements for attachment. First, the collateral has to be in the lender's possession, which is fairly uncommon, or there has to be a written security agreement, which is most common. Second, the secured party has to give value, and third, the debtor has to have some rights in the collateral. So, you can't use something that you don't own as collateral. It has to be something that you have rights in. So if those three requirements are met, then the secured creditor can attach and get that enforceable security interest against the debtor. Let's talk for a minute about the written security agreement, since that's the most common way that a security interest attaches. That written security agreement should contain, at a minimum, the description of the collateral. It should contain the amount of the debt in terms of payment. It should contain the name and address of the parties, the creditor and debtor. And it should be signed by the debtor, and in some states they require the creditor to sign as well. Now, another way that a security interest might attach is through what's called a purchase money security interest, and that is a security interest that arises when a seller-lender extends credit for part or all of the purchase price of specific goods. And we'll talk about that a little bit on the next slide. But once that security interest is created, the next step is to perfect that security interest. And perfection has to do with what are that secured creditor's rights in the collateral against other creditors who might try to obtain that collateral. As far as methods of perfection, how does the creditor go about perfecting a security interest? The most common way is by filing a financing statement. And where do you file that? Well, it's something that you would file with the Tennessee Secretary of State's office. And let me bring over here so you can see it, a sample of the financing statement. If we get past all these instructions and directions, we can get to the actual form itself. It's called a UCC-1 financing statement. You can see the information that it contains. It has a place for the debtor's name and contact information, a place for the secured creditor's name and contact information, a place for a description of the collateral, and then some other information that they require. So this would be filled out and filed with the Secretary of State's office, and once that is done, other people that are interested in taking a security interest in someone's collateral can contact the Secretary of State's office and research that and make sure that nobody else has already taken a security interest in the collateral that they want to have a security interest in. A second method of perfecting is the purchase money security interest in consumer goods, and this type of perfection is automatic. The creditor doesn't have to file anything. The reason for that, I think, is a very practical one. Consumer goods would be things like TVs, refrigerators, washers and dryers. You can imagine how much paperwork it would be if Sears or Best Buy or JCPenney had to file something on every TV or appliance that they sold. The third option for perfection would be if the creditor retains possession of the collateral. That's very unusual, so that won't happen very often. Why does the creditor want to perfect? Well, like I said earlier, it establishes that secured creditor's rights against other creditors with an interest in that same collateral. And the idea being that the first creditor to perfect his or her security interest is going to get priority. So they're going to get first dibs on repossessing that collateral if the debtor defaults. So determining priority, what happens if two or more creditors claim a security interest in the same collateral? Who's going to win? Well, if it's a secured creditor versus an unsecured creditor, the secured creditor is going to win every time. If it's a perfected creditor versus another perfected creditor, then the first to perfect, the first one to file a financing statement, is going to win. And what if it's two unsecured creditors battling against each other? Well, then it's essentially a race to the courthouse. Whoever can obtain a lien first is going to prevail. But our general rule is the first security interest to perfect has priority over other perfected or unperfected security interests. So what about the unsecured, those people that don't have a security interest in any collateral? What can they do? Well, there are some liens that they can obtain, and a lien is a claim on property securing a debt. Some liens are statutory in nature, meaning they're authorized by statute. The two most common are mechanics liens and artisans liens. A mechanics lien can be obtained by someone who furnishes improvements to real property, for instance, a general contractor or a painter. If you fail to pay them, they can obtain a mechanics lien against your real property for the work they've done. Similarly, an artisan's lien provides or can be obtained by someone who has provided improvements to personal property. The artisan has to have possession of the personal property and has to give you notice that they are claiming that lien. And so the auto mechanic, if they repair your car and you fail to pay, as long as they still have possession of the car and give you notice, they can assert that artisan's lien until you pay in full. The second type of lien that might be obtained is a judicial or judgment lien, where you go to court and get a court order. And there are several options that you can pursue in this situation. Usually the judicial lien process is kind of a two-step process. You'll go and get a judgment, and then if the debtor does not make good on the judgment, you may have to go back and get another order to execute on that judgment. But some options available to you: you could get an order of attachment, which is an order to seize the debtor's property even before the judge rules on the validity of the judgment. And in order to do that, the creditor has to show a likelihood that the debtor is going to dispose of the assets before a proper judgment can be obtained. Another option is to obtain a writ of execution, and that is a court order authorizing the sheriff to go out to the debtor's location and seize whatever property they can and sell that to satisfy the debt. The third option is garnishment, and that's just a court order authorizing the creditor to seize a debtor's wages, and there's a limit on how much or what percentage of a debtor's wages can be garnished. I would note that in Tennessee, the creditor, once they have a judgment, they have 10 years to enforce that. And if for some reason they don't or are not able to enforce it within that 10-year period, they can go back to court and renew that and get an extension. So let's talk about repossession. If you're a secured creditor and the debtor defaults, you can just go and repossess the collateral. You don't have to do anything extra because you have that security agreement. You can just go take the collateral. So you see how that speeds things up. You don't have to go to court and go through that whole process. But if you're an unsecured creditor, meaning you don't have that security agreement, then you do have to go to court. As far as repossession goes, the general rule is that you can't breach the peace. That means you can't go busting through locked doors and knocking down fences and things to repossess collateral. You have to do it in a peaceful way. And then if you're going to sell the collateral, the requirement is that you have a commercially reasonable sale so that you at least try to get a decent price. Now, some property is exempt from judgment by statute. Examples of things would include certain Social Security benefits, personal property up to $4,000, clothes, family pictures, some things like that. The idea is that we want to prevent the debtor from becoming totally destitute, and so these exemptions help toward that end. I would also point out at this point the difference between a surety and a guarantor. A surety, think of that sort of like a cosigner. It's someone who is liable to the same extent as the primary debtor. Whereas a guarantor is secondarily liable, meaning the creditor has to try and collect from the debtor first, and then if the debtor can't pay, then they can go after the guarantor. One thing to note here is that if there is a material modification made without the consent of the surety or guarantor, it may release the surety or guarantor from their responsibility. And so if you're the creditor, you want to make sure that the surety or guarantor is in the loop on any modifications that you make on the loan or the repayment agreement. Now I want to say a few words about bankruptcy. First, bankruptcy can be filed voluntarily or involuntarily. Usually bankruptcy is voluntary, but if a creditor is concerned that the debtor may be insolvent and unable to pay, the creditor can force that debtor into bankruptcy involuntarily. Either way, once a bankruptcy is filed, it places an immediate stay on collection efforts, meaning that creditors can't contact you, they can't call you, they can't send you letters. And I think sometimes this is why people file for bankruptcy, because they want to get those creditors off their back. The bankruptcy process is, of course, overseen by the bankruptcy judge, but there is a bankruptcy trustee who sort of manages the bankruptcy process. They administer the bankruptcy estate, they divide up the assets and so forth. And this is where the importance of having priority in those secured debts comes into play, because as the bankruptcy trustee is dividing up the debtor's assets, those who have priority and have secured debts are going to get paid first. Briefly, the three main types of bankruptcy. There is the Chapter 7 bankruptcy, in which there is no repayment plan. That's a liquidation. The court, before they approve a Chapter 7 bankruptcy, will go through what's called a means test to determine if you qualify for that liquidation. Their preferred method of bankruptcy is a Chapter 13, a repayment plan, because that ensures that the creditors may get more of what is owed to them. The Chapter 11 bankruptcy is a business reorganization, and so you may hear about that in the news. If a business files for bankruptcy, it's usually under Chapter 11. Now, there are some exemptions. There are some things that are not included in the bankruptcy estate. Because we don't want the debtor to become totally destitute. Once the bankruptcy process is complete, there is a discharge that is issued that kind of resets everything for the debtor. However, there are some things that are not bankruptable, such as taxes that are past due, child support, federally insured student loans, as well as any money or items that you obtained by fraud. And so that's a quick overview of secured transactions and bankruptcy.